The ultimate goal of the I Do philosophy is an I Do marriage contract, which serves and protects both partners. Before we draft such a contract, we should familiarize ourselves with basic legal issues. Stay with me, and we will discuss them. Greetings, daters of all ages. I'm John F. Whitney, author of the book I Do, If It's Equitable, a philosophy for dating and marriage to avoid the potential horrors of divorce. I will be your host and your guide as we discuss the I Do philosophy. This is section 2, video 9 of 9. We'll make it binding. Legal aspects of the I Do philosophy. The red square at the bottom right hand corner of your screen is a subscribe button. If you feel I am doing a good job, please consider clicking that subscribe button anytime during this video. Mike Tyson said you can't stay married in a situation where you are afraid to go to sleep in case your wife might cut your throat. Mae West said, I'm a great housekeeper. When I get divorced, I keep the house. Erica Jong said, there is a rhythm to the ending of a marriage, just like the rhythm of a courtship, only backward. You try to start again, but get into blaming over and over. Finally, you are both worn out, exhausted, hopeless. Then lawyers are called in to pick clean the corpses. The death has occurred much earlier. Joan London said, why the courts don't tell a husband who has been living off his wife to go out and get a job is beyond me. And finally, an unknown source said, have you heard about the new divorce Barbie doll? It comes complete with all Ken's accessories. We'll make it binding. Legal aspects of the I Do philosophy. Lawyers. Most of us dislike them. Some of us even despise them. At least until you need a lawyer or one wins a case for you. Then they are the greatest gift God gave to earth. Perhaps we so dislike lawyers because they make their living through disagreements. That is, a lawyer's singular reason for existence is to argue for someone against someone else. This adversarial situation is common in every case a lawyer accepts. Conflict is the rule. Of the many types of lawyers, ambulance chasers and divorce attorneys certainly seem to invoke the largest share of negative public opinion. Of the two, however, divorce lawyers not only make their living through conflict, but they also reap financial gain from the darkest of human emotions. Greed, spite, avarice, deceit, and vengeance, to name a few. Apparently for a divorce lawyer, the formula for financial gain is simple. The more conflict to resolve, the more money they make. But in defense of divorce lawyers, they would not need to exist if the divorcing couple could find their own fair and equitable answers to the conflicts between them. How sad to know that former lovers, once intimate and passionate, now become adversaries, possibly to the point of violence. How sad to know the current divorce system would have the couple fight over the least amount of assets or property. For example, I heard of one case where the divorcing couple collectively spent $15,000 fighting for an asset worth $500. How insane is that? Especially given the fact that the judge split the amount in question 50-50. How sad to know that potential issues of conflict are, more often than not, ignored by the majority of couples. They fail to resolve these issues while dating and before marriage, as the I Do philosophy advocates they should. The ties that bind. Remember, the I Do philosophy is but a means to discover potential problems and establish common solutions. Remember also, a prospective partner that balks at the fair and equitable approach of the I Do philosophy is likely not worth marrying in the first place. However, as valuable as it might prove itself to be, the I Do philosophy alone is not enough to provide you with a confident, secure relationship or marriage decision. Unfortunately, the reality is that the only true way to be secure in a relationship is to have a document that protects you from the vindictive behavior of another. Warning: no matter what was said by either of you during courtship, a verbal agreement is is not worth the paper it is printed on. A written contract of some sort is the only way for each person to unquestionably state and be held accountable to their beliefs and expectations. Therefore, do not fail to seek the advice of a capable contract lawyer today, before marriage, to minimize or eliminate the need for a divorce lawyer tomorrow, during divorce. Prenuptial agreements versus the I do marriage contract. Let's briefly discuss the difference between a prenuptial agreement and an I do marriage contract. A prenuptial agreement is an understanding or arrangement between two parties. It must also meet certain requirements that vary by state, but in general, it must be reasonable and fair at the party's execution of the document, and it must be reasonable and fair at the time of divorce judgment. It also requires full and open disclosure of all property, assets, and liabilities by both parties. I'm no attorney, but I can already see a multitude of ways to challenge a prenuptial agreement just by the definition alone. On the other hand, a contract is a specific agreement with terms and conditions that are legally binding and enforceable in court. Which would you rather have in hand if it was needed? An attorney will need to assist you in drafting a specific document that incorporates each point that you jointly accept as you follow the I do philosophy. He or she will be able to answer the specific requirements of your state as to the wording or content of the contract you seek. Their goal is to create a contract that is as ironclad as possible. Let this contract lawyer do their best to protect you from a divorce lawyer that might be waiting down the road. Once they understand the intent of the contract you are drafting, insist they find possible loopholes and seek their input to close them. Better to pay this contract attorney a few $1,000s now than a divorce attorney many thousands of dollars later. Granted, the cynic will argue that the I do philosophy merely takes the divorce attorney out and puts the contract attorney in. Fine. It must be less arbitrary and difficult to argue breach of contract than it is to argue the intangibles of a divorce or the vagueness of a prenuptial agreement. Damages in a contract situation are usually limited to the specifics of the contract in question and the breach that is alleged. Moreover, the vindictive future ex-spouse will not be able to take the Harley then burn it if the Harley is exempt from the marriage, or your exclusive property acquired during the marriage, as the I do philosophy advocates. With or without something like the I do philosophy to guide you, at some point before you marry, an understanding of the marital and divorce laws in your state is absolutely essential. This knowledge might also help you, your prospective partner, and your attorney hone the I do marriage contract to a razor's edge. This knowledge will enlighten you as to what lies ahead once married or facing divorce. In turn, you might further protect yourself from potential financial disaster. What you don't know can hurt you. These marriage and divorce laws are readily available in most bookstores, from your state house bookstore, or at a law library. No fault versus fault. To divorce, you need grounds or reasons to petition the court to dissolve the marriage. The specific reasons a court will grant a divorce vary from state to state. However, divorce falls into one of two major categories or types: no fault or fault. No-fault divorce. A no-fault divorce simply means that only one person in the marriage must believe that the marriage is doomed for divorce to be sought or granted. Usually the court does not trouble itself with why the divorce is sought, as neither person is at fault for the failed marriage. The court is not being cavalier. It simply does not matter. The no-fault divorce situation does have its logic. If both parties agree to the divorce and can agree to the distribution of assets and dissolution of debts, then a straightforward divorce form alone is sufficient for the divorce to be granted. I'm told that in a no-fault divorce, if you agree on everything and argue over nothing, you don't even need an attorney. A divorce, as most marriages, will take little or no thought to complete. Fault divorce. Fault divorce occurs when either or both persons do not agree with the divorce, as they do not agree with the grounds or reasons for the divorce. The most common reason for divorce is the often nebulous and all-encompassing irreconcilable differences. However, reasons for fault divorce are often vicious, or allege some form of physical or emotional abuse. Does the reason for the divorce matter? Yes, as one person is trying to place all blame in the failed marriage on the other. Therefore, the faultless victim must be compensated or given restitution by the party at fault. Fault divorces usually mandate a legal separation period of some length. Apparently, this serves to determine if the marriage can be reconciled. It may also allow the couple to agree on a divorce settlement prior to the actual divorce filing. In any case, after this period of separation, either person can petition for divorce on any number of grounds. At any point along the way, either party can file a contested divorce where they do not accept the divorce petition or alleged grounds of the other person. Fault divorces become long and expensive situations to solve. To fight or not to fight. Be aware that most of the wailing and gnashing of teeth, the most terrible of human emotions, the darkest of all human behavior, will result from arguments over the division of assets and dissolution of debts, especially if one person is being spiteful or if either person is acting on principle. Indeed, the very worst of human emotions are possible in divorce situations where one or both persons are fighting for honor, what's right, what they deserve, or using divorce to be cruel or spiteful. Therefore, weigh carefully what you should fight for, or if you should fight at all. Remember, at this point, it's too late to hide any assets or lie about your financial status. Criminal liability is possible if you attempt to defraud the court. As a result, any and all assets and property are fair game to a potential vindictive ex. If it costs too much in legal fees or peace of mind to fight over something, then perhaps the best decision is to surrender it to the other person, or sell it, or give it away. If you need an example of such a scenario, find the movie The War of the Roses. It speaks volumes as to just how ugly divorce can become. Community property. Do you live in a community property state that considers marital assets as jointly earned regardless of who earned them? Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington, and Wisconsin are community property states. For those of you in a community property situation, an I do marriage contract is absolutely essential. Why? There might be an exception to the mandated division of marital assets. As you recall from the previous videos, Ms. Taylor's situation is perhaps a perfect example. Moreover, through the I do philosophy and contract, you can define and exempt the premarital assets as well as define and limit post-divorce gains by any ex. Financial risk is thereby confined to the marital assets only. When is enough enough? Why would you bother to define such limitations prior to marriage? The fault in our current divorce system, and the cause for so much of the abuse and violence the system breeds, is the enough is enough position a judge uses to maintain a standard of living which an ex might fight for. Basically, the enough is enough rule states that at some financial endpoint, as determined by the court, enough money is enough for the former spouse to maintain the lifestyle they became used to during the marriage. Why? Or rather, why should an ex-spouse expect to maintain a lifestyle that they cannot earn by their own means? Why should marriage entitle them to a lifestyle their income and or education cannot make possible? Or can make possible, as we will see in the Mick Jagger discussion to follow. Let's be honest, any gain or increase in wealth, assets, property, or lifestyle above and beyond their premarital lifestyle should be considered manna from heaven. But no, they expect to keep a lifestyle that their ex alone made possible. The courts could solve this discrepancy by finding an enough is enough point somewhere between the premarital and post-divorce lifestyles. But who am I to advise the court on this issue? Well, you can find it for yourself in a carefully drafted I do marriage contract. What would Solomon have done? Most judges, I hope, are fair in their distribution of marital and premarital assets. Granted, state law is their minimum guide. However, I trust they can use a great deal of discretion in deciding each individual case before them. Most, if not all, judges give strong consideration to any contract that has been drafted. They also consider the contribution of each partner in the assets being fought over. My oh my, how the I do philosophy contract should make a judge smile. How straightforward their effort and decisions will be with a fair and equitable I do contract before them. Other questions to ask and answer. What responsibility do you assume regarding the financial obligations your spouse enters into? Can your income be attached to meet the debts or obligations of your spouse? If the I do philosophy is applied, what is the procedure for an uncontested divorce? What percentage of income is mandated for child support? How long is alimony paid for? In a divorce action, are both spouses entitled to the income of the other? Are divorce-related classes mandated? Also, take some time to research if, for some reason, divorce can be filed in a state or country other than the one you were married in, or I can't get no satisfaction. 20 years ago, Mick Jagger was going through another divorce. His first ex received a mere $750,000 in her divorce settlement. His subsequent wife wanted half of his $250 million estate. This in spite of the fact that her career as a supermodel earned her $40 million, of which Mick got not a penny. As I understand it, round one did not go the way she wanted, so she filed for divorce in her native England, where she hoped the courts might give her lots of satisfaction. In the end, she was awarded $50 million and a London estate worth $8 million. There are countless other cases where a couple is married in one state, but resides in another, or files for divorce in another. In this situation, one spouse files for divorce in a state where the laws are favorable to them. The other spouse countersues in a different state where the laws are favorable to their wants. In the end, the lawyers make out like bandits. Again, determine if residing in any state, even on a part-time basis, would somehow mean that you might face a divorce action there. Your attorney, in conjunction with specific items included in your I do marriage contract, should be able to assist you in finding an answer to this potential pitfall. Of course, your state might be totally biased against your well-being. If so, perhaps you should marry in another state, have a mock wedding and reception in your home state. Or perhaps the legislature might need to revise the marriage and or divorce laws in your state. Properly applied, the I do philosophy and contract should give both partners satisfaction. This concludes our discussion on Will Make It Binding, legal aspects of the I do philosophy. Our next topic will be a real-world example of the I do philosophy. I hope you will join me. If you learned anything of value, please consider hitting the like and share button. Leave me a comment, especially if you have a question, concern, problem, or issue we might be able to solve together. Or perhaps you can assist me in improving my presentations to you. Finally, if you feel that I am worthy of your time and effort, please consider subscribing. And don't forget to hit the bell icon so you will know when I upload a new installment of the I Do Philosophy. Until next time, date wisely, date safely, and remember, I do if it's equitable.